Compliance Resolution of 16 September 48. This difference in the result between the two scales not unnaturally caused considerable dissatisfaction amongst the employees concerned, and after unsuccessful attempts to get redress on the executive side, they filed through the representative, the respondent, the present application of the Article 226. Now please go directly to paragraph 5 on page 125. On the first question, Rule 44 of the fundamental rules runs as follows. Subject to any restriction which the Secretary of State in Council may, by order, impose upon the powers of the Governor General in Council or the Governor General in Council, as the case may be, and to the general rule that the amount of a compensatory allowance should be regulated, that the allowance is not the whole source of profit to the recipient, the local government may grant such allowance to any government servant under its control and may make rules describing their amount and the conditions under which they may be drawn. Under this provision, it is a matter of discretion with the local government whether it will grant dearness allowance, and if so, how much. That being so, the prayer for mandamus is clearly misconceived, as that would be granted only when there is in the applicant a right to compel the performance of some duty cast on the opponent. Rule 44 of the fundamental rules confers no right on the government servants to the grant of dearness allowance. It imposes no duty on the state to grant it. It merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus can issue to compel the exercise of such power, nor indeed could any other writ or direction be issued in respect of it, as there is no right in the applicant which is capable of being protected or enforced. So we would draw on this particular observation in support of our submission that there is no fundamental right. Now there is one more decision which may be of assistance, which is at page 129 of this paper book. So this is Videsh Sanchar Nigam Limited versus Ajit Kumar, 2008, 11 SEC, page 591. And may I request you to go to paragraph 51 at page 147.
Paragraph
51.
Yes.
So DR is dearness relief. Paragraph 51. It is well settled that dearness relief is a matter of grace to the government servants and not a vested right, and hence a claim against the government for the grant of such allowance at a particular rate is not justiciable. The grant of dearness relief at such rates and subject to such conditions is the prerogative of the central government in terms of Rule 55A of the CCA Pension Rules 1972. Rule 44 of the Fundamental Rules for the grant of dearness allowance impose no duty on the state to grant it, and it merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus or any other writ or direction, therefore, could be issued to compel the exercise of such a power, as there is no right in the employees which is capable of being protected or enforced. So this is, of course, as your lordships have noticed, a judgment rendered by a panel of two learned judges, the 2008 judgment, but it draws on, as the court has seen, the state of Madhya Pradesh judgment versus Mandawar, which is a constitutional bench judgment dating back to 1954. So we believe we would commend this approach to the court, which is to say that there is no right as such. It's a matter of discretion, and therefore a mandamus doesn't lie, because there's no public duty or there's no duty in terms of the rule. So that's going to be the broad framework as far as our submissions are concerned as well. Now, this was an effort to answer some part of your lordship's question. Now, may I just go through the first and foremost?
We are in fact, to be honest, we are relieved. Both sides are not taking this plea that it is a fundamental right. We have doubts about this finding at page 21 of the High Court.
Yeah, I think that's a fair assessment, judging from what they said. Yeah, and what we say. But I think we are also buttressed by this authority, which your lordship will consider in the correct perspective. But we feel that this seems to be the settled law, that this is a matter, is obviously a matter of discretion as far as the state. That's an important prism to examine this entire case under. Because I want to now take your lordships to what they sought and what was granted by the tribunal, which has been sustained.
Please proceed your way.
Yes, I'm very grateful. Now, there are, the petition is on record, but the application rather before the tribunal is on record. But it's not typed very accurately. So may I just request you to go to page 268 of the paper, volume 1. So I am first taking your lordships to the prayers, which I think are reproduced accurately here.
266 of the?
Of the two, yes, it begins at 268. It's a copy of an order. Volume 1, brother.
This is the prayer before the tribunal.
Yes, it's elsewhere as well, but the typing is not very accurate, so I'm just reading it from there.
No problem.
This was the application.
268. Yes.
May I place it? The application has been filed by two organizations of the West Bengal state government employees seeking the following amongst other relief. A direction upon the respondent authorities to forthwith release the 50% Dearness Allowance, which is due up to January 2006. This is a typing error, it should be 2016. Immediately within a period of 1 month from the date of receiving of the order. So this is one part which they ask for.
Yes.
B. A direction upon respondent authorities to immediately comply with the report of the recommendations of the 5th Pay Commission report positively and without fail within a period of 1 month from the communication of the order. C. A direction upon the respondent authorities to release the 50% of Dearness Allowance as the state government, without releasing the 50% Dearness Allowance for mere eyewash, set up the 5th Pay Commission, who recommended for 10% interim relief upon the basic pay, but no whisper about due 50% Dearness Allowance. And unless the court intervene into it, there may be every possibility of forfeiture of that 50% due Dearness Allowance, which is the penultimate goal and gain of the state government, and the applicants will suffer irreparable loss and injury. And D. The applicants pray for relief order directing the respondent authorities to grant 50% of the Dearness Allowance as that of the central government, with arrears up to January 2015 within a period of 2 weeks from the date, it should be date of order. Now, this was the framework of the prayers which they saw. So, I want to just mention a couple of things. You will notice, one, there is no challenge to any rule which is extant. Number two, there is no challenge to any memorandum at all, which has been issued by the state government, explaining the scope and the amplitude. So these are two things which your lordship may just at this preliminary stage know. Now may I request the court to go through the tribunal's decision, where I want to place just a few paragraphs and then the operative directions. That you will find at page 462. Yeah, second volume.
Yes, that's right. Remove this.